Mr. Medrami.
My lords, my lady, I left a question open, in fact, a couple of questions open, and I'd like to start from a question that Lord Justice Popplewell had put to me. And the question was, at what point in the Section 73 analysis in the March judgment does the law book transaction objection essentially get trimmed down to the Stava June 2011 objection that is now before the court? If we can go back to the judgment, page 20, just to remind ourselves, at paragraph 63. And it's the subparagraph Roman number 8. So that was the broad description of what the judge calls the law book transaction objection. And it is described in the broad terms that we saw yesterday. At this point, that description reflects the broad objection that had been pleaded in the amended particulars of claim. So that was the starting point. And then if we go to the analysis from paragraph 118 onwards, that begins at page 43. Well, it begins at page 42, that whole section, but it's from page 43 that we need to concentrate. Paragraph 118 summarizes points that the judge says emerged from the rejoinder. There's a point 1 which is a bit unclear, to which he then comes back. There's a point 2 which is about Diag, and then the third point is the one that matters. Czech Republic's rejoinder raised the jurisdictional objection based on the law book transaction, which, and then he quotes, in practical terms, means that Mr. Stava cannot assert any claim herein in respect of events that occurred after June 2011. And then there's a separate bit that is quoted from the rejoinder. And for the period after June 2011, there is no basis on which the tribunal could deem Diag Human to be a Swiss investor. So that's what he has identified so far as emerging from the rejoinder. At paragraph 120, he says, I'm satisfied that the arbitral tribunal admitted the law book transaction as a jurisdictional complaint. He's not using the whole phrase law book transaction objection. He's saying the law book transaction issue as a jurisdictional complaint. Although I have to draw the court's attention to the fact that later on in the paragraph, he does seem to use a bit confusingly the full expression law book transaction objection. However, whatever confusion one may be left with at this point is put to rest by the following paragraphs. Because at paragraph 121, he says that leaves an issue as to the scope of the objection taken and whether it was limited to breaches after June 2011 or whether it extended to all claims. The Czech Republic's position on this issue was unclear and inconsistent. And then he refers back essentially to the passages that are cited at paragraph 118. Then his clear finding at Roman number 1, in relation to Mr. Stava, I am satisfied that the objection is limited to breaches post-dating June 2011, which is also how the tribunal understood the objection. And there is a reference to the tribunal. And then if we turn the page, paragraph 122, this is where the judge summarizes his conclusion on the no control and Corona Trust objections. And it begins by saying the issue of whether these objections were made in respect of the period from June 2011 onwards is finally balanced, as from the rejoinder, from the passages that he had referred to before. It was a finely balanced issue, whether the point had been taken. For present purposes, what matters is Roman 5, where he says the scope of those objections was not advanced on any wider basis than the law book transaction. They relate to Mr. Stava, so far as claims from June 2011 are concerned, and to Diag's status as an investor. So that finding about the Stava June 2011 objection being limited to the claims from June 2011, the breaches from June 2011, the conduct giving rise to the breaches after June 2011 is affirmed in relation to no Karuna, to no control and Karuna. And so the conclusion of this exercise is that we have these two objections, Stava June 2011, which is ability to claim in respect of conduct after June 2011, and then the Diag Human objection, which is for later, and which, as I said, is an investor point. He's plainly not concerned with Stava as an investor because that description just doesn't accord with what he's saying and wouldn't make sense. But with Diag Human, he says it's about the status of Diag Human as an investor. Ultimately, my lord, my lady, even if there were any missing step in this analysis, which I don't think really there are, it doesn't matter because the ground of appeal is clearly limited to conduct after June 2011. And I'd like to go back briefly to that document. In fact, if we can start from the appellant's notice, that's core bundle tab 1, page 4. Appellant notice identifies the point on appeal as the objection that the tribunal had no jurisdiction to consider a claim in respect of conduct after June 2011. And the point
I should tell you that I know we had some problems with the live note this morning. Nothing's coming up on my screen in terms of the transcript.
Yes, I thought it was mine malfunctioning, but it isn't. Yeah, no one has it.
Should we swap that?
Well, as long as we're getting the hearing is being recorded and a transcript is being made, I dare say we'll cope.
I had an issue this morning with I can swap the laptops back and get it, but it will take me a few minutes.
Yes, I think so long as the transcript is being made, then I think we'll carry on. Yes, thank you.
I just thought I'd flag it up in case it wasn't.
Right. So the reference was core bundle tab 1, page 4, the appellant's notice. I think it is on the extended display.
Yes.
And that's where they identified the basis for the notice. And then at core bundle 2, we have the ground of appeal, which, as we've seen, identified the error as in relation to sorry, I'll give the reference, core bundle, tab 2, page 1. Then the judge erred when he concluded that the objection that the tribunal had no jurisdiction to consider a claim by Mr. Stava in respect of conduct after June 2011 was not an objection to jurisdiction. And then in the rest of the paragraph, the specific error is described, which is essentially, as they put it, an error of construction of Article 9. What prompted the red amendments in the skeleton were certain obiter comments by Mr. Justice Foxton at a ruling on PTA 6 months after permission was granted on this ground. We don't think those comments can change the scope of the appeal. They cannot create a new ground. They might be a bit confusing, but he was dealing really with the question of the arbitration agreement and why he was denying permission to appeal on the point of the arbitration agreement. But ultimately, the ground of appeal before the court must be what is set out in the claimant's ground of appeal, and it can't be widened. And just to give an illustration of how this confusion can infect other aspects of the case, if we can turn to tab 16 of the bundle, this is the appellant's notice on control, and at page 13 we see the order that they're seeking on the next appeal, to which Mr. Bridges and Dr. Paulette will turn after me. But the at paragraph C, for example, they are seeking that the award be remitted to the tribunal to reconsider whether Mr. Stavert standing to bring his claim for breaches of the treaty. So they, again, widening it into an opportunity to revisit the entire question of standing in respect to claims. I note that, interestingly, they describe it as standing, which of course accords with our case, that this anyway would all go to standing, but it cannot go to standing in respect to all the claims. It just can't. It can only go to standing at best in respect to claims connected with alleged breaches post June 2011. That's it. Now, with that in mind, my lords, my lady, I'd like to move back to the treaty analysis. I'd gone through what I described as the characterization test and adopted respectfully the approach that Mr. Justice Foxton has set out in Diag and in Korea and Elliott on the correct approach to characterization under section 30. And I'd moved on to the text of the treaty. It might be helpful at this point to look at what we said in our skeleton on Article 9. We can go to Core Bundle, tab 5, page 17. It's paragraph 41. So in the indented quotation, we sought to capture what Article 9 would have had to look like in order to make the claimant, the appellant's case, good. So we said that provision would have had to say, for the purpose of solving disputes between a contracting party and an investor from the other contracting party with respect to investments and concerning claims for breach of the substantive provisions of this agreement at the time when the investor holds the investment, etc., etc. So it's that language or language to that effect that must in some ways be read into this provision or derived from other provisions in order to characterize this question as they are seeking as jurisdictional. Now, the language that they would need for the variant 2 objection would be different from that language. For that objection, we didn't set it out here because we didn't think it was a point that we would need to address. But the variant 2 that Dr. Bastin had identified would require language along the lines of, with respect to investments still held by the investor at the time of the submission of the dispute, or something along those lines. But it would be a different target. The target for this objection, if they can, for them to prevail on the jurisdictional characterization, is something along the lines of what we have here. And it's analytically a distinct target from the one they would have to hit if the variant 2 were to be anywhere in play. Now, both of these targets are non-jurisdictional, is obviously our case. So even if we were to fight the variant 2 battle, we would still be in squarely non-jurisdictional territory. And Lord Justice Popplewell asked yesterday, is it subsection 1 or subsection 3? I think it would be 3. These targets would be in the space of 3 rather than 1. If we are wrong on the question of characterization, and if one had to make an exercise under that section, that's where those targets would, I think, fall. But it's not obvious.
Sure about that. If variant 2 is open, and the argument is the offer is only to arbitrate with someone who remains an investor at the time of commencement of proceedings, that's a dispute about the scope of the arbitration agreement, isn't it?
So 2 points on that. The first one is that in one of the cases to which I'm going to take the court, which is the Colombia case, Alcor, the reason why the Greenwood Tribunal reached that conclusion is because the definition of investor contained language along those lines. So the term investor was defined as national juridical persons who invest or who owns. We'll get the correct language. But investor was someone who owned in the present tense an investment, and that was quite key. Now, if one has a provision like that, then the issue may well go to section 1 and be about the status of investor. In this case, we know that that can't be the issue because the judge said it's not about the status of it's the status of Diag as investor, but not the status of Stava as investor is in any way in play. And we know, that's my second point, that they're making their argument against Stava on the basis of Article 9. And so their own case would suggest, if we're wrong on characterization, something under subsection 3 rather than subsection 1. But in theory, one could try to make that case by seeking to read that language that I've said would have to be read into Article 9 into Article 1. And then, you know, we would move from section 3 to 1. Neither works. Both would be admissibility. But in this case, the investor point is precluded for the reason that I gave before, that any challenge to Stava as investor is finished. I hope that answers the point. But perhaps when we get to the Colombia case, it may be clearer. If I can now turn to the judgment, which we have at paragraph, sorry, it's where we are, it's paragraph 12, tab 12. And if we go to the paragraphs, core bundle 12, sorry, core bundle 12, and it's the paragraphs where the judge deals with Article 9, paragraphs 145 to 147, page 51. And the judge, in our respectful submission, correctly found that there is nothing in Article 9 which limits the offer to arbitrate to breaches which occur at the date when the investor still owns the investment they made. And again, this suggests, to go back to the point I was making submissions on before, that in the judge's mind, we are in a subsection 3 space rather than anything to do with the investor. And then he continues in his analysis, and he says, paragraph 146, if the question is asked whether the dispute between Mr. Stava and the Czech Republic as to his continuing ownership of the investments from June 2011 is a dispute with respect to investments, the answer is, in my view, clearly yes. The contrary argument requires the court to read into Article 9 a limitation which is not expressly stated, something the applicable principles of interpretation make a challenging task. And his reasoning on the construction of Article, on the construction of the treaty and on the difference between the two objections is perhaps even clearer if we turn to the analysis of the Diag June 2011 objection in the following pages, starting at paragraph 148. Paragraph 153, page 53 of the core bundle 12, he says, this is now Diag June 2011. In any event, the issue for me is not whether a loss of Swiss nationality before the offer to arbitrate is invoked precludes recovery, but whether any rule of this kind is jurisdictional. I'm satisfied that it would be. It involves an argument by the Czech Republic that the offer to arbitrate is only capable of acceptance by investors meeting the nationality requirement at the time the offer is accepted. Whether that contention is right or wrong is jurisdictional in character. The nationality matters for Diag because if it is not controlled by a Swiss investor, it is not Swiss. The nationality is not a point in play for Mr. Stava because he's Swiss throughout. And any attempt to challenge that has failed. So that's the bright line that separates these two objections, and I think it also helps us understand the reasoning of the judge and also what was being challenged and why the target was very much the construction of Article 9. Now, to go back to the appellant's analysis under the VCLT, as I said yesterday, their case is based on ordinary meaning, context, object, and purpose, and also good faith. I think I've gone through the ordinary meaning elements and explained, well, quite simply, that language contains certain elements: dispute with respect to investments, investment, investor, and a dispute between a contracting party and an investor. And those are the key elements of the offer to arbitrate, and other terms cannot be added to it. Context is an aspect of treaty interpretation on which in the opening submissions my learned friend placed great emphasis. It is entirely proper to rely on other provisions in a treaty to interpret the terms of the provision with which we are concerned, because the rule on interpretation is the ordinary meaning to be given to the terms in their context. And then the second paragraph of Article 31 specifies that context includes the text, the preamble, and the annexes. So that's absolutely fine to look at other treaty provisions. I have no objection to that at all. But I think that exercise needs to be conducted properly. And if we go to the treaty, which is a supplementary bundle, tab 22. The first provision to which I would draw the court's attention for purposes of interpreting Article 9 that is relevant is obviously Article 1.2. 1.2 gives us the definition of investments, and treaties can define investments in different ways. This is a very broad and inclusive definition, and it must have been obvious to the parties of this treaty that by extending their offer to arbitrate to any investor with a dispute with respect to investments, they were extending an offer to arbitrate that was, in terms of subject matter, very broad, because investments is a very broad category in this treaty, unlike a number of other treaties that contain various qualifications, including sometimes temporal qualifications. Here we have Article 2.1 that my learned friend has spent quite a bit of time on, which does contain a temporal limitation, but it does not help their case. If we can turn to Article 2.1, it's scope of application of the treaty, and it simply provides that the agreement shall apply to investments in the territory of one contracting state by investors of the other contracting party if the investments have been made later than the 1st of January 1950 in accordance with the laws and regulations. In terms of scope of application, this is a very broad provision. Every treaty that satisfies the definition in Article 1.2, together with any inherent element that the term investment may be found to possess, and that satisfies this broad temporal requirement, is a protected investment. And any dispute with respect to an investment that is protected in terms of Article 1.2 and Article 2.1 is a dispute that can potentially be submitted to arbitration. The provision just does not contain the kind of qualification, limitation that the Czech Republic needs. It does not say that the agreement shall cease to apply to investments once they are sold, for example. And I will see in a second why that interpretation will be untenable under this treaty. It does not say that the treaty applies as long as investments are continuously held or anything to that effect. And yet it is a provision where the parties decided to insert a temporal limitation. And so it must be right to assume that had they wished to add further temporal limitations, they would have done so expressly. But so far, just looking at the language that and the context that derives from these provisions, Article 1.2 defining investments and Article 2.1 defining the scope of application of the treaty, all we are left with is the fact that the offer to arbitrate in Article 1 is an offer to arbitrate with respect to investments as long as they were made after June the 1st, 1950, and as long as they satisfied definition of investment in the treaty. That's all that these provisions in terms of context can give us. And as I said, I would go further on Article 2.1 and say that it isn't simply neutral, it actually assists our case precisely because there is an express temporal limitation. The contention that one should read a further temporal limitation into it is very ambitious. And if we add to this the fact that they are relying on 2.1 as context so that they can then change 9. So they're relying on language that does not appear in the contextual provision so that they can then change the terms of the provision that matters. In terms of interpretation, that exercise simply can't be fruitful. The other relevant contextual provision is Article 6. I think the court is very well alive to this point, so I don't think I need to spend much time on it. But
is the consequence of your argument on Article 2.1 that if I am a Swiss national and I can point to an investment which comes within the scope of the definition, I acquire treaty rights, even if I've got nothing to do with that investment?
well, in what situations? What I'm trying to imagine the factual scenario. I think if a Swiss
I've given you the only facts that I'm putting into my hypothesis.
I think if a Swiss investor has an investment that meets the definition, has
an investment into that, which immediately raises potentially temporal questions.
It doesn't. I think the only temporal question is that he would have had to make the investment after 1st of January 1950. That's the only temporal issue. If the Swiss investor,
So there's a temporal issue, not only as to whether it is after 1950, but whether he's made the investment. If I'm a Swiss investor and I've never made the investment in the investment I'm claiming qualifies, then surely no treaty rights. And to that extent, there is a temporal connection in that I must at some stage have made the investment.
well, yes, but in that situation, you know, the case would rather be one where there is an investor, someone who could make an investment but did not make an investment, and so there is no protected investment. I mean, the investment has to be made, and yes, it can't be an investment made by someone else. So in that sense, you know, that there has to be at that point which is why Article 1 says investment made by. But that's where the connect.
You say at that point. At what point?
At the point when the investment is made. In the language of Article 2.1. So investments made by investors after, that's an investment made by an investor that will be protected under the treaty. So the investor who made that investment will have treaty protection from that moment onwards in respect of that investment.
I'm suggesting to you that does have a temporal.
Yes, no, but that
temporal link, because there has to be, at whatever point of time you take as your temporal link, there has to be an investment by an investor, not.
I think we have to be very careful.
Two distinct elements.
I think we have to be very careful to distinguish between different kind of temporal connections. There is a very basic temporal connection, which is the one that appears in Article 2.1. An investment made by an investor after this date. And of course, that is the case and I have to accept it. Any further temporal connection, an investment continuously held by the investor after the investment was originally made, is a separate temporal connection. And that does not arise. And the same would apply in the case of a number of other temporal connections that one could imagine. There is a temporal connection, but it is strictly in the limits in which it appears in Article 2.1. There is no further connection requiring continuous possession, continuous holding, or holding at a particular time. The time that matters is 1st of January 1950. The investment must be made by you. If you tick that box, if the investor ticks that box, then they're through the gateway. Then all of the other scenarios, selling this investment, selling part of the investment, selling it and reacquiring it, all of that is not jurisdictional under this treaty. Because they're different kind of temporal limitations that simply don't apply here. Here, the only limitation that the treaty requires for the investment to be protected is that it must be made by the investor after that date, and that's it. It doesn't require, it must be made and held by the investor throughout after that date. There'll be a completely different requirement, and it's not what Article 2.1 says. Article 6, we submit, assists with our interpretation. The clear and express terms of Article 9 need to be given effect to, because it is evident that the parties had in mind expropriation, which by definition, in the cases of direct expropriation, means that an investor will have lost the investment. And my Lady Justice Andrews asked my learned friend, why shouldn't that also apply to other ways in which investments are destroyed? Because an investment can be destroyed through breaches of the fair and equitable treatment, which is what happened to a large extent in this case. The cooperation agreements with the Czech hospitals, the cooperation agreement with Novo Nordisk, the goodwill and know-how, probably not the know-how, but certainly the goodwill, they were all destroyed by that Boyer letter. And it wasn't a breach that was expropriatory, but it was an FET breach. But in that context, where all of those reputation matters so much and those relationships matter so much, it meant that in effect the economic value of the investment was destroyed.
Well, I think Mr. Bastin's answer to that was along the lines, or included, that expropriation and its equivalents would be catered for by a principle of good faith. What do you say about that?
Well, my answer to that is that with respect, the interpretation that he's putting forward is an interpretation that isn't really a good faith interpretation of the terms of this treaty. So to try to add all of these limitations to the offer to arbitrate that are simply not there, it is a stretch in terms of good faith. Those limitations are not there. The offer to arbitrate is as broad as it is. It is confirmed by these provisions, of which Article 6 is one, but Article 1.2 is another, and Article 2.1 is yet another. It is also confirmed by Article 5 and the free transfer provision. I'm afraid I haven't got the English text with the missing term, but in German it's Zahlungen, and Mr. Hall and I were tasked with solving a German language issue, which was much more complicated than this below, but I think everybody would be content that Zahlungen means payments, and that's the German text. But the bit of the provision that matters is the letter D, because it says this obligation to free transfer applies so each contracting party in whose territory investments have been made by investors shall grant those investors the free transfer of, and then D, the proceeds, including possible capital appreciation arising from the sale or the partial liquidation, not even forced sale. So of course an investor could sell an investment and would still have treaty rights, and that investor would be able to submit a dispute under this treaty. That must be the fair interpretation. And I think an attempt to...
I'm sorry, I'm being a bit dense, but what does this article actually entitle them to? Does that mean once they've sold the investment, they can get their money out?
Yes, so there can be a dispute with respect to the state not complying with an obligation that in this case is specific to a situation where there is no more an investment, but there are only the proceeds of the
I follow that, yeah. Thank you.
Yeah. So I think these are all contextual elements that assist that core interpretation of Article 9. Now, turning to object and purpose, I think the simple point here is that there is just no basis in our submission for arguing that the general language in the preamble should be read as the Czech Republic contends. The maintenance of favorable conditions for investments, for example, does not necessitate any particular temporal limitation to the offer to arbitrate. It's just a huge leap, and one could make that leap in the other direction, really. So it doesn't go anywhere. My learned friend has also made much of the principle that for states the starting position is sovereignty, no consent to foreign or international jurisdiction. That's fine, I accept that point, but it doesn't change the terms of Article 9. It is true for individuals or companies too. They're not normally presumed to have accepted arbitration.
I pointed out to him that that was a totally circular argument because it begs the question of what it is that the state has agreed to.
Exactly. So it doesn't really go anywhere. So I think on object and purpose, given what the preamble says, which is fairly high level general language, it doesn't go anywhere, and if it does go somewhere, it probably suggests that if in doubt, one should lean towards the investor and the protection of the investments rather than in any other direction. On good faith, my lords and my lady, just two brief points. I think first, good faith interpretation simply can't do all the work that the appellant is expecting from it. Again, it can't be used to add terms to the treaty, and in fact, as I suggested before, attempts to interpret the treaty in that way and to change the text in that way may themselves be interpretations not in good faith. And the second point, this may also apply to submissions that have been made in the context of the other appeal, is that we have to be careful to distinguish between good faith interpretation and good faith as a more general principle. Interpretation is an objective exercise, and so good faith interpretation must lead to some objective meaning. The fact that the interpretation has to be a good faith interpretation doesn't mean that it's a moving target, depending on individual circumstances. Now, there may be situations where good faith or good faith-like principles can be deployed at an admissibility or merit stage in a dispute to disqualify an investor from advancing a claim, for example. So it may be said, you know, the correct investor can't claim, but that's a different use of the term of those of that group of principles of good faith.
Substantive obligation of good faith as opposed to a question of good faith interpretation.
Exactly, exactly, and it's important to distinguish the two because good faith interpretation, we have to end up with an objective meaning. If I can now go to a few cases, conscious of time. Aguarla, which is it's bundle 6 of your bundles, and it's tab 27. Page 8, we have the provision in this treaty that contained the offer to arbitrate. It was a differently worded provision. I think it did contain some interesting differences. In particular, the consultation period was blended into the offer. But anyway, as a background, it doesn't matter for purposes of the point that I derive from this case, and that point is at page 11 from paragraphs 71 on the time condition. And the Paris Court of Appeal says, it is clear from this statement that the parties have clearly adopted a broad definition of the term investments irrespective of whether they were made before or after the date of entry into force of the agreement. So this treaty didn't even have a provision like our Article 2.1, so it was even broader in that sense. They have, however, opened the offer of arbitration to disputes arising after its entry into force, irrespective of the date on which the investments concerned were made. It follows that the treaty does not make the arbitral tribunal's jurisdictional power subject to a temporal condition of completion of the investment, which is not included in the treaty, but limits the benefit of its procedural protection to disputes arising after its entry into force, which in that case wasn't an issue. In this case, it was an issue and a part of the dispute, but that question is not in play. The international investment rule opposed by Uruguay, according to which the BIT cannot apply to acts committed by the host state before the claimant has invested in the host country, does not set out a condition of consent to arbitration, but a substantive condition of the protection provided by the treaty in respect of that investment, a condition which the court does not have to review. As I said, it was a different provision, but that analysis on how slow a tribunal or a reviewing court has to be in adding temporal conditions that are not there in the offer to arbitrate is one that we agree with. Now, I have some further points, mainly responsive to some of the authorities that you've been taken to. And I think I'd like to start with Tatneft, because the appellant makes much of sort of clash between the Diag judgment and Tatneft. You can take Tatneft, which is at your volume 4, and it's at bundle 18. So the paragraph in Tatneft that is really key, we spent already quite a bit of time on it, is that paragraph 87, because that identifies the specific point. I think just to remind ourselves, in Tatneft, Mr. Justice Butcher was only addressing the specific objection that the relevant investment was acquired after the dispute arose. That was the objection before him. Dispute and then investment. And then here he says, more specifically, I accept paragraph 87, page 21, apologies, page 21. More specifically, I accept that the limitation is, as indicated by the tribunal in the Philip Morris case, as to whether the relevant investment had been acquired before the time at which the alleged breach of the BIT occurred, and that the offer to arbitrate is only in respect of disputes where that was the case. So, and we'll see in a second what Mr. Justice Foxton says about this, but the reason why he characterized this differently is because of the term dispute. And I imagine dispute between an investor and a state. So if there is a dispute with respect to an investment that is protected under another treaty or not protected at all, and that investment is bought by another investor, if in a sense that dispute is trafficked or sold, or the investments rather, can the disputes move as well with the sale of that investment? Does it mean that the next investor, who may have treaty protection because of his nationality, does that investor acquire a dispute that can be submitted to arbitration under the treaty that applies to him, for example? And that's simply a very different objection. And Mr. Justice Foxton made precisely this point in his judgment at paragraph 147, called bundle 12, page 51, which we say is entirely correct, and there is really no disagreement. Page 51, so he says, I should acknowledge that this conclusion can at some level be contrasted with the conclusion reached by Mr. Justice Butcher as to the second issue before him, whether under a different BIT, the requirement that the investor make the investments before the breach was a jurisdictional matter. And then there is the reference to the treaties not having retrospective effect, which was an important part of that analysis, of course, because the investor wasn't in the picture when the dispute arose. So it's very different. And then
You say that although in his first sentence he says that at some level his conclusion can be contrasted with Mr. Justice Butcher, the analysis in the rest of the paragraph shows that really there is no contrast at all.
that's right. And I think what he's saying is that from a first read of those analysis, one might think that there is a contrast, but then if one follows through Mr. Justice Foxton's reasoning, he concludes it is easy to see why the interpretive canon which is reflected there in the provision stipulating when the treaty comes into force combined to provide a sufficient basis for reading a limitation of this kind into that offer to arbitrate. That consideration does not arise here. I think the interesting thing about the two analyses is that they seem to have in mind two slightly different routes to the same conclusion, which is that that particular objection would be jurisdictional. Mr. Justice Butcher focuses on the term dispute, judged from that paragraph 87, and Mr. Justice Foxton has in mind the fact that because the treaty was not in force as between the state of nationality of the investor who's bringing the dispute, or rather the investor wasn't in the picture, so that treaty wasn't in play, that is the relevant consideration for adding this temporal limitation. Both of them think the principle of retroactivity is relevant to the analysis. So there's perhaps a different nuance, but ultimately it is not one that would need to be resolved, at least because they would have reached the same conclusion. But it's not the objection we are dealing with now. Now, moving on to some of the international investment jurisprudence, and the parties have referred to quite a lot of cases in the skeleton. I will focus on the cases to which the court has been taken in opening. But at the outset, I would note, I think, 4 points. The first one is that the kind of investment treaty award that could be of assistance to this court would be an investment treaty award by a tribunal in an arbitration seated in England, applying a similar provision to our provision, where the question of characterization arose and where that particular tribunal turned its mind to how to resolve that question in light of Section 30. If we had an award like that by an English-seated tribunal that deals with characterization, turning its mind to the considerations that are relevant here, it would be undoubtedly of great assistance.
Why would even that tribunal be concerned with Section 30?
Well, they might be, because they might think at that stage that when they, they probably wouldn't be concerned because jurisdiction admissibility doesn't go anywhere in. Exactly.
Even if they said, for the future, we make clear that it's our view,
yes,
it is jurisdictional within Section 30, that
it wouldn't bind
that wouldn't bind the court.
It wouldn't bind, absolutely. Yeah. I mean, it may be that, you know, the parties out of caution in those proceedings will say, could you please characterize it in the right way, because it would make life a bit easier. But Lord Justice Popplewell is absolutely right. It might make it a little bit easier, but it wouldn't make a substantive difference in the end, because it doesn't turn on their decision. But I'm saying in terms of persuasive force, because this is really what we're talking about, you know, how much persuasive weight to give to these decisions of investment tribunals. If there was a very eminent tribunal having developed that sort of analysis, it would of course be of interest, and I'm sure the court would look at it carefully. But that's not the sort of precedent to which we have been taken. I think the other points, which are really the points that Mr. Justice Foxton makes in his judgment, is that the investment treaty approach cannot be determinative of these issues, and that the analysis of the distinction, that's the third point, is very compendious, because it is not usually based on an articulation of clear principles that could assist our courts in the task with which they have to undertake. And then the final point is that it doesn't matter to them whether something goes to jurisdiction or admissibility, unless they're so focused on the future that they're already trying to deal with problems that might arise later. But it's not an issue that concerns them in the same way, to say the least. So those are the 4 points to keep in mind. There is an attempt that we have drawn the court's attention to in our skeleton to set out a bit more objectively this distinction between jurisdiction and admissibility in international investment treaty law, and that's by Professor Douglas, whose work has been referred to before. I don't think I need to take you to his analysis, but I'm just mentioning it because insofar as someone did try to look at this question with some degree of conceptual rigor, the distinction between jurisdiction and admissibility in international investment law, he has reached the same conclusion on this particular issue that we have. And you have his article at tab 32 of the legal authorities. Now, I know that Professor Douglas is being relied upon for different purposes on different sides. I would say that...
You say he's good in parts.
Well, I think what he's doing here is developing a more conceptual analysis. And a conceptual analysis perhaps can age a bit better than an analysis of a term of a treaty that inevitably depends on how the jurisprudence evolves. So I think what he was doing there was a bit different, and I think it is something that we can rely on, but it is not really material or decisive for our case. Now, moving on to the awards, if we go to Phoenix, I think the court is very well alive, and I'm conscious of time of the points in Phoenix. It's volume 1 of your bundle. I'll speak there very briefly. And it's tab 6. So paragraph 145, internal page 59 or PDF page 59. Phoenix Tribunal dismissed the claim on the basis that the claimant's purported investment does not qualify as a protected investment under the Washington Convention and the Israeli-Czech BIT. So comments that they have made on the other issue were at best obiter. I also note, if we go to paragraph 45, page 19, yes, so it would appear that the from this paragraph that the investor was not presenting a claim in respect of conduct after the sale of the investment. As to say, claimant indicated that the funds were released on that date, but that it still seeks compensation for the wrongful freezing of those funds until January the 8th, 2008.
Something gone wrong with those dates? The second seems to be before the first. Misunderstood.
I think it's seeking compensation only until that date. January the 8th was the date.
They were frozen until the 6th of March, but they were sold by Phoenix on the 8th of January, so they're limiting their claim for the wrongful freezing to the 8th of January.
That's right.
As I understand it.
That's how I understand it, yes. I'm grateful, my lady. And I think that there was the other point in this award to which Lady Justice Andrews had already drawn attention, which is paragraph 70 at page 30, where indeed it is said, it is now contested that there was no longer any investment of the claimant after that date. So we submit this award really can't be of any assistance to this question, and even if one were to look at it as an international investment law distinction, which is not the right exercise, there's not much that one could derive from that analysis. Now, turning to Werklinghaus, Werklinghaus is a bit complicated as a case, not the easiest award to follow. It's in your second volume, and it's tab 10. So if we go to page 40, this is where paragraph 136, but yes. So that's where we have those two sections. Is there an investment and PVE standing, on which my learned friend spent a bit of time. Just if we go back to the first section, these are the Czech Republic's arguments. Paragraph 137, it is common ground that PV is an investor within the terms of the treaty. The extent of the investment is in dispute, but there's no dispute on the shareholding. There is a dispute on the loan. And there are two arguments that the Czech Republic advances on the loan. The first argument, this is in that paragraph 137, I'm paraphrasing, it maintained that the tribunal had no jurisdiction over the claims, first because PV had failed to demonstrate that he had a legal or beneficial interest at the time of the breaches, and second, because the loans to Comfort originated as a bank credit from Sparkasse Essen. And then they quote from a provision in the protocol to that treaty that excluded from claims to money credits from third parties. So it's the argument was that being the case, they did not constitute an investment within the terms of Article 1. Then we have that analysis on standing, or rather the positions on standing. And if we jump to paragraph 165, this is the paragraph on which the Czech Republic places reliance. So here the tribunal makes a finding in relation to the first of those arguments, and it makes a finding in these terms. The tribunal concludes that PV retained no legal or beneficial ownership interest in MFTK after 8th of March, and the important part, accordingly, the tribunal holds that it has no jurisdiction to hear the claims in respect of receivables, and that's the part that appears to assist my learned friend's case, and to some extent I can see how this point would be taken against me. But to just follow the analysis through, in the next section, the tribunal turns to the second argument, which was whether a credit could be an investment under the treaty, which is a straightforward definition of investment argument. And their conclusion, page 50, paragraph 172, is that that particular investment cannot qualify for treaty protection because of the provision in the protocol that we had seen.
That's the second of the two objections.
That's the second of the two objections.
Does that have any implications on the rationale for the first bit, finding in favour of the objecting party on the first of the two?
So, no, and as I say, I accept that that analysis is against me, but to continue with their application of the principles, they then go on to find in the following section whether there were breaches, and they do consider claims in respects of events that occurred after the 8th of March 2001, which was the date of the sale. And then if we turn, then we, I think, can do an analysis of all their breaches findings, but the dispositif is quite revealing. The dispositif is at page 62 and 63. So, paragraph 214, pages 62. There's no reference to jurisdiction in the dispositif. So the tribunal in the dispositif says, for all the reasons given, and rejecting all submissions to the contrary, the tribunal hereby declares and awards as follows. Point 1, it denies a certain request for declaratory relief. Point 2, it denies a certain request, different request for declaratory relief. Point 3 also goes to denial on declaratory relief. Point 4, the orders for compensation are denied. And then if we turn the page, it says all other claims are dismissed. So as I said, it is not the easiest award to follow. I accept that that point can be taken against me, but were they really saying we have no jurisdiction, or were they rather saying that principal ground on which the Czech Republic succeeded is one that leads us to dismiss all other claims? If I read the dispositif, there is no jurisdictional finding, in spite of what I accept is a paragraph that does go against me. But for that reason, I think the reliance that can be placed on this award must also be very limited. Now, if we turn to Avon and Costa Rica, that is bundle 4, and that is LA 17. Go to page 19, LA 17, tab 17, page 19. It's trying to find the place in the award, which one normally has, where they reproduce the entire dispute settlement, all the relevant provisions, but it's not reproduced in the award. But we can see from paragraph 18 that it was a different dispute settlement provision. This is the NAFTA Dominican Republic Trade and Investment Agreement. And it says claimants submitted their claim pursuant to Article 1016 1A of the CAFTA DR, which provides that the claimant as a disputing party on its own behalf may submit to arbitration a claim that the respondent has breached an obligation under Section A of Chapter 10, that's the investment chapter, provided that the claimant has incurred loss or damage by reason of or arising out of that breach. It's just a more complicated provision. It doesn't have the hard-edged clarity, I think, that other provisions have, and that certainly our provision has. The objection, just not a key point, but an interesting one. If we go to page 96, paragraph 267, the respondent's objection is described as an objection requesting the tribunal to decline jurisdiction to hear claims. That's sort of language that one uses more in the context of admissibility rather than jurisdiction. It's just a point that I note. And then if we go to the paragraphs that is relied upon by my learned friend, the analysis of the relevant date for determining ownership, which starts at paragraph 289. So the paragraph on which they rely is paragraph 301, which reads in their favor. But I think in response to that, I would note a number of things. I mean, first, if we look at paragraph 300, and the exercise that they've just done. They say the claimants have failed to show whether the sales were for distress prices compared to those previously earned on sales made prior to 2011. That they
Showing that they've suffered a loss.
Yes. So it's probably that part.
The qualification for being an investment.
Exactly.
Or part of the qualification for falling within the scope of the clause.
That's exactly right, my lady. But in a clause that doesn't have that qualification, it would be really quite something to insert what would normally be really a merits analysis into demonstrating whether a sale was distressed or not, reading into a provision that doesn't have that. In the paragraphs before, the tribunal had looked at the Mondev principle. As the court knows, Mondev is a case on which we rely. So the tribunal is trying to explain, actually, why don't we go to the paragraph before, paragraph 219. Claimants seem to evoke the Mondev tribunal's reasoning with their assertion that the project had been destroyed by the actions of the respondents. Paragraph 219, just a page before.
Before we go there, if you go back, please, operator, to the page you were just last on.
Page 104. Yeah.
Yeah. Bearing in mind paragraph 300, they say an investor who disposes of ownership of the investment in question before arbitral proceedings shouldn't be eligible to seek the treaty's protection. If you bear in mind that the qualifying investor, they have to show that they've suffered loss and damage as a result. If they've disposed of the asset, they won't have suffered loss and damage before the breach, will they?
Yes, not quite.
Although it may be that it's connected with that. I can see that they might suffer loss and damage and then dispose of the ownership. But I wonder if the two are connected in some way.
I think that they probably are. It certainly is a very complex requirement for an investor. I accept that sort of treaty would be challenging. It also raises questions about how does an investor meet an obligation to mitigate losses in those circumstances if they have to hold on to something so that they can keep their treaty rights, even if they have an option of mitigating losses that involve some sale. But interestingly, this tribunal still thought that even applying that sort of provision, which is an R provision, they wanted that comfort that this was not a situation of distressed sale. And that's why I think that paragraph 300 is interesting, because I think it shows, if anything, a reluctance understandable reluctance by the tribunal to just apply it to core and actually provide some merits analysis. But we don't see how any of this can assist in the present case. If we go to alcohol, that is volume 6, and it's tab 24. So the provision that I mentioned before is at page 29. Term investor shall mean the government of a contracting state or any of its national or juridical persons who invest in the territory of the other contracting state. That's how they define investor there. It's someone who invests. There's a present tense, and that's what they need to give effect to. And that explains why, if we go to paragraph 256, page 70, that explains why the tribunal in this key paragraph starts by referring to Article 1 and 2, third sentence rather. Article 1(2), as quoted above, merely provides that an investor is any of a state's natural juridical persons, and then quotes, who invests in the territory of the other contracting state. And then at the end of this paragraph, they say, the more natural reading of the relevant provision is that it is not enough that a person made the investment at some point in the past. They're referring to the more natural reading of a provision that has this distinctive language. That's what they are applying. And
Present historic rather than the past tense. The word invests is read as a present historic.
yes. So that's the natural reading they give to those words, and it really turns on that who invest part of the.
Continues to be.
And just of course to be clear that this case dealt with a different jurisdictional objection, which was whether Alcor was an investor at the time that arbitration was commenced, which we say is not the Stava June 2011 objection. But in dealing with that objection, they are applying a very different provision and reading it in a certain sense. And the interesting thing that whole exercise that follows, through which my learned friend took you, of how they seek to approach the other cases, is an attempt to go to look at the natural reading and say, well, there may be cases where that natural reading would have to be approached with some caution if the investor, for example, has lost the investment because of the action of the state. So they are stuck with those words. They want to interpret them correctly as on the basis of ordinary meaning. And then they want to explain why even that reading would not exclude certain situations. But it is an analysis that doesn't really assist the Czech Republic's case.
I mean, although in alcohol they obviously decide what they decide, is their analysis really focused on the tense of the word invest, or on what they describe as the general principle of international law at paragraph 251? That seems to be their starting point. And I can't see anything about analysis of the precise tense of the word invest in the definition of investor.
I think that's a different general principle that they're referring to. So that is the principle that there must be an investor, there must be an investment at the time when the proceedings are commenced, which in this case for Stava is satisfied because he was Swiss in December 2017, and with Diag we have that issue. I think what they're dealing with in the subsequent section, the effect of sale of the investment, is trying to decide how the sale of the investment can be squared with these provisions, because they say at 256 the claimant argues that Article 9 contains no requirement that a claimant must be an investor at the time it commences arbitration proceedings. Article 9 must be read together with the definitions in 1.1 and 1.2, and then they move on to 1.2. So I think in interpreting their Article 9, they are taking a different 1.2 into account. In any event, this objection is not the objection that we're dealing with, because
so their rationale is that you've got to have both an investor and an investment at the time of the arbitral proceedings being commenced. You then look at the definition of investor. Because that's in the present tense as somebody who invests in the territory, they've got to invest in the territory at that time. That seems to be the rationale.
yes. I think that's their analysis. And then they go through cases where there may be exceptions, notwithstanding this natural reading, because of certain circumstances. But their starting point is the opposite of our starting point.
Yes.
That is really the key difference.
Just before we leave that, the question of special circumstances, I note that at 276, which is where they're 275 to 276, they refer back to Avon. And they say, leaving aside the reference in Avon to retroactive application of the treaty, they deal with expropriation. Say, well, that would be, in principle, you can't allow the state to profit from its own wrong. But Avon also at 301 treated as special circumstances if the investment were lost by the actions of a third party.
Yes.
That wouldn't then. They don't deal with that here,
No.
which would be difficult to fit into a good faith analysis of
Quite.
explaining special circumstances.
Yes. I think another interesting point they make in that section where my lord just took us, in paragraph 275, they say the tribunal considers these are necessarily fact-specific and that it is neither possible nor desirable to attempt to create a comprehensive list of what might constitute special circumstances. It is appropriate to look to what has been regarded as special circumstances in other awards. So they seem to recognize we're not in a territory of hard-edged determinations, if anything. So all of the qualities of a jurisdictional determination being hard-edged and clearer boundaries don't seem to be present in this kind of a determination. But as I said, it's a different case. If we turn briefly to Azerbaijan and Armenia, now, again, I probably don't need to spend very much time on this, but this was a multilateral treaty, the Convention on the Elimination of all forms of discrimination, of all forms of racial discrimination. And Armenia had become a party in July 1993, and Azerbaijan in September 1996. The treaty was in force even before Armenia became a party, but as between Armenia and Azerbaijan, the treaty entered into force from when Azerbaijan became a party, because every multilateral treaty can be broken down into a series of bilateral relations for these purposes. So the question is whether Azerbaijan could submit a dispute that related to events that predated Azerbaijan's own ratification of the treaty. And the answer was no. And yes, the court does have that jurisdictional analysis, but that sort of objection would be closer to the temporal objection, the main temporal objection in this dispute that is already finished, which was the question whether our dispute predated the entry into force of this treaty. The main ratione temporis objection that the Czech Republic raised against our claim was that the dispute predated the treaty. And so there couldn't be jurisdiction ratione temporis, and that point is gone. So Armenia, Azerbaijan goes in that direction. One needs to establish, are the parties to the treaty? Is the treaty in force between these two parties? If it is not in force, what do I make of disputes or conduct that predates the entry into force of the treaty? So conceptually, it goes to that dispute, that objection that they had, which was to say your dispute is about things that happened in 1991, just a few months before the Czech Republic became a party, or There was a separate argument that they made. The Czech Republic wasn't the successor state and all that stuff, which is all water under the bridge. But it's a dispute that was in that category, and I really don't think it can assist in the characterization exercise that is required here. Just give two references to a separate opinion by very distinguished judges. We don't need to go there, but one is Judge Tomka, former president of the court, which is at LA tab 29.3, who makes the point that while he agrees with the conclusion of the court, he thinks even that issue should have been characterized as admissibility rather than jurisdictional. And Judge Cleveland, the American judge, 29.2, tab 29.2, who said, paragraph 10, questions of jurisdiction turn on the interpretation and application of a treaty's compromissory clause. Admissibility, actually maybe I should put it on the screen, it's not fair otherwise, it's page 3, so tab 29.2.
Because we don't have this in hard copy.
Yes, apologies, I just realized it's yes, we can provide them after lunch, and if we go, yes, we go to the page before actually, paragraph 9. Yeah, sorry, can we have 29?
So what is this document?
Sorry, just 1 second, I'm just checking.
Dissenting opinion in something.
This is Judge Tomka's opinion in the Azerbaijan and Armenia case. And it, I think it was a separate opinion, not a dissenting opinion.
Paragraph 8 says it's a dissenting opinion.
Apologies. Oh, this is Tomka was dissenting.
This is Cleveland that you've got on the screen. I think you've given the wrong reference.
Sorry, I'm being told that I've given the wrong reference.
That's Cleveland.
This is 29.2.
Oh, I see. I did have the wrong reference. It's okay.
It's 29.2.
Yeah, yeah. No, that's fine. So if we turn the page here, 29.2. Apologies. It's 29.2. We were in the right document. I got confused. If we can go back to 29.2, Judge Cleveland. If we start from page, yes, from that page. Then if we turn the page, sorry. So it's the part where she says questions of jurisdiction essentially turn on the interpretation and application of a treaty's compromissory clause. And then in the previous paragraph, which is between the 2 pages, it starts at the previous page, she tries to capture the concept of admissibility. So that's what admissibility, on the other hand, it starts there, concerns the exercise of the court's jurisdiction where the jurisdiction is already established. The court has previously concluded that a party standing to bring certain claims is a question of jurisdiction. Anyway, nothing much turns on this point because really this case goes to a different question and one that has already been determined. But I just wanted to indicate to the court that the opinions by judges Cleveland and Tomka actually provide an analysis of admissibility that we say is closer to where things should be, even if this were a characterization under that that analysis. So that's with this case. There are other cases that the parties have made submissions on in our respective skeletons. I don't need to go there, except briefly. I think Mondev we have already seen. I don't need to go there. I'm pressed for time. I think the only point that probably is left for me to make briefly is on the question of standing. We have raised the respondents' notice on standing simply to say that objections which relate to standing, as in fact we've just seen in Judge Cleveland's comment, are routinely characterized in international legal practice as going to admissibility rather than jurisdiction. And interestingly, the Czech Republic recognized that the objection was non-jurisdictional in its own pleadings in the arbitration. The references to their requests for bifurcation are in our skeleton argument, and I think Mr. Goodman has already taken the court there. And the judge said at paragraph 114 of the judgment that this matter was raised in the request for bifurcation, and I quote, as an issue which was expressly not jurisdictional. And then further, the award, paragraph 114, we can look at it briefly, supplementary bundle, tab 23, page 126. The tribunal accepted the characterization by the Czech Republic of its objection as an objection that goes to standing, and as they had seen it, as going to admissibility. So the point here is simply that if one were to consider that the international law characterization is somehow crucial to this exercise, which is not a principal case, then one should look at how standing objections are routinely characterized in international law, and they would go to admissibility rather than jurisdiction. If I can have just 1 minute to check. I think that ends everything I had to say. I've got sort of strange sense of having forgotten something, but if I have, I have.
I'm sure someone will remind you
Someone
before
will
your
remind me.
time finishes.
It's collective forgetfulness because I don't seem to. So I think that's probably it. Yes, unless I can be of further assistance.
Thank you very much.
Thank you.
Mr. Richard, you're next, are you?
Yes, I will. I might just take a few seconds to get the elective sorts out. Thank you. Lord, my lady, I will now address the court along with my learned friend Dr. Parlitt on the Czech Republic's appeal on the control issue. And that's the issue that arises on the test under Article 1(1)(c) of the treaty. And I will explain shortly how we will divide our submissions. So to recap, the question arises under what the judge defined as the Diag SE June 2011 objection. We saw that again this morning in the March judgment at paragraph 123. And it concerns whether, given the events in the second half of 2011, the position at the end of 2011 was that Diag Human fell within the definition of an investor for the purposes of the treaty, and thus whether it could bring a claim in the arbitration. It does not concern Mr. Stava as a claimant in the arbitration, and neither does it concern whether Diag Human held the investments. Those are no longer open to challenge before the court. So if we could just turn up the treaty, please, which is at supplemental bundle tab 22. The court will be familiar with this now. And if we could turn to page 2, please. And page 2, thank you very much. As I say, we've looked at this a few times already. The relevant provision for the purposes of this appeal, of course, is Article 1. And we see there that the term investor refers with regards to either contracting party 2, and then we move to C, legal entities established under the law of any country which are controlled directly or indirectly by nationals of that contracting party. And we can stop there because we're not concerned with the last few words. We're not talking about Diag Human being controlled by a Swiss entity. It's as to control by a Swiss natural person. And of course, it's not open to the Czech Republic any longer to challenge Mr. Stava's nationality. That was one of the challenges that was held to be barred. He is Swiss. He therefore comes within the meaning of a national of a contracting party in Article 1.
And the question is simply whether Diag Human is controlled by Mr. Starver.
There is a secondary question, which your lordships will have seen on the respondent's notice, as to whether the daughters come into that question at all, controlled by a Swiss national, and that along with that comes the question of whether that's even open to us to argue, and we will come to that later.
Yes.
So the Czech Republic's appeal on this has two limbs. The first limb of their appeal is one of treaty interpretation. And for clarity, we'll call this the treaty interpretation limb. And under this limb, the Czech Republic challenges the judge's decision that direct or indirect control does not have to be de jure control, but can be de facto. And by that, the court will recall paragraph 171 of the judgment. He meant that control does not have to arise out of a legal right or derive from a proprietary interest in the claimant entity. Now, on Tuesday, my learned friend Mr. Dunning gave some additional clarification to what this part of their control appeal is, so this first limb, and he said on day 2, page 117, line 19 over to page 118, it's applicable to any country from the world, and I'll just read out the key point. And he says, and that could be, perhaps most normally would be, an absolute majority of the shares, or potentially a relative majority conferring control, or some other legal right which gives voting control over the company. That is our primary argument. And then he refined that a bit further on Wednesday. We don't need to go there. So that's day 3, page 30. So that's all the treaty interpretation limb. That is what Dr. Parlett's going to be addressing the court on. The second limb of their control appeal is in the alternative, and that's on the assumption that they've lost on the treaty interpretation limb. And on this basis, they challenge the judge's decision that on the facts of this case, there was de facto control by a Swiss national. And they say he was wrong in law in that conclusion. This part of their appeal, therefore, looks at the application of the de facto test to the facts of this case. And we call this the de facto assessment limb. Now, my learned friend, Mr. Dunning, repeatedly stressed that this was an appeal and saying that the judge was wrong in law, but we do contend, and we will get to this, that there are aspects of this limb of their appeal that do impermissibly seek to reopen the facts. So we will come to that. It should be noted on this part of the appeal, which I will be addressing the court on, that it's not a broad challenge to the judge's decision. Instead, their skeleton argument identifies just 3 points on the appeal. And it's probably helpful to turn up their skeleton argument at CB, so core bundle 18, page 20, and it's paragraph 56. And this is where they summarise what this limb, this alternative limb of their appeal is. So as they frame it in the first few sentences of 56, if the court disagrees, then in the alternative they submit that the facts as found by the judge were insufficient in law to constitute de facto control, in particular as it was common ground that the Carina Trust was valid and effective, a state of affairs which necessarily depended on Mr. Starver not being in control outside the trust framework. And then they say 3 points arise. So the first, A, is any interpretation which takes account of de facto control only does so on the basis that a legal or proprietary interest is necessary, but in some circumstances insufficient, such that Diag fails the test. B, and they have the one that we heard a fair bit on yesterday, and now any analysis of factual control requires an assessment of the legal attribution point, which my Lord Justice Popplewell suggested is better described as one of a capacity question rather than necessarily attribution, and that in fact was then the basis upon which my own friend Mr. Dunning proceeded in his submissions.
The agency point for simplicity.
Capacity or agency, but perhaps not attribution. Yes. And we didn't actually hear anything from my learned friend on A. We did hear from him, as I say, on C, and then he very briefly touched at the end of his submissions. Sorry, I think I misspoke there. We didn't hear from him on A. We did hear from him as the bulk of his submissions on B, and then he touched very briefly at the end on C, which was whether analysed under Liechtenstein law, international law, or English law, having taken the position that the Corona Trust is valid and effective, the respondents cannot here take the inconsistent stance that the ex facie position can be contradicted by factual control outside of that framework. So that's what we're dealing with. And as I say, I'll be dealing with this alternative ground. My friend Dr. Parlett's going to be dealing with the treaty interpretation ground. Just before I hand over to her, two observations. The first is about what my learned friend acknowledged is a thread that runs through both limbs of their appeal on control. And this is that the judge made a critical error in somehow, he said, ignoring or looking through a valid and effective Liechtenstein law trust. Now, it's put in various ways. And one of the ways is the suggestion that Mr. Staver's own position in these proceedings, that the trust was valid and effective, is somehow relevant to the judge's finding of de facto control within the meaning of Article 11C. And as we read it, it's put even higher than that. We understand it's said that Mr. Staver and Diag are acting in bad faith, or perhaps without good faith, by contending at the same time that he was in de facto control for the purposes of the treaty test, and also that the Corona Trust is a valid and effective trust under Liechtenstein law. And perhaps it's helpful at this point to look at the judge's reasoning on this at 218 of the judgment, and that's at Core Bundle 23, page 68. So it should be said before we start looking at this that the conclusions that the judge sets out are ones he reached having read hundreds of pages of Liechtenstein law, reports and exhibits, and having sat through hours of cross-examination of the Liechtenstein law experts. So what we see there is he says, finally, I've been asked by the Czech Republic to address an argument which on my findings I do not believe arises. So issue 3, considered by the Liechtenstein law experts, was would Mr. Staver be free to contend that in the reality the trust was operated other than in accordance with the trust deed or applicable law, or that the existence of the trust can be disregarded for his benefit? Unsurprisingly, the answer from both experts was no. And the Czech Republic submitted a similar conclusion following under international law. In the event, no case was advanced by the arbitral claimants, that's my clients, that in reality that was the case, nor that Mr. Staver should be permitted to disregard the existence of the trust. And I've made no such findings, nor have I found that Mr. Staver and Dr. Rabanza acted or agreed to act in a manner inconsistent with the trust. And then he says, my findings of fact have been made on the basis that the principles of Liechtenstein law and the terms of the trust deed apply and cannot be ignored, and that there was no agreement by Dr. Rabanza to act inconsistently with the terms of the trust deed, nor did he do so. Then he says, my conclusion nonetheless was that the cumulative effect of my findings is that at the relevant time, Mr. Staver had sufficient de facto control of Diag SE for Diag SE to constitute a Swiss investor for the purposes of Article 11C of the BIT. In reaching that conclusion, I have sought to give full effect to the principles of Liechtenstein law and the terms of the trust deed, and the need for the Corona Trust, the trustee, and Mr. Staver to act in accordance with their requirements. Now, I take the courts to that because the judge's clear conclusion is that there is no tension. There's no tension on the facts of this particular case, and taking into account Liechtenstein trusts law, which is of course different to English trust law, There's no tension between those on the one hand, and on the other, a finding of de facto control of Diag Human under the treaty by someone in the position of Mr. Stava. So having, sorry, I put that perhaps unhelpfully confusingly. There is no tension, having looked at those principles and the facts, between on the one hand, the finding of de facto control by Mr. Stava of Diag, and on the other, the existence of a valid and effective Liechtenstein law trust. Now that's the tension that the Czech Republic was positing, and the judge in his conclusions there in 218 said there was no such tension. Now we will look at the key building blocks to that conclusion later, and they are principally to be found in Annex 3 of the judgment, paragraph 1 to 60, which of course are not open to challenge. One of the building blocks, but not the only one, was the finding that on the facts of this case, the trustee would have been fully compliant with his duties under Liechtenstein law in following Mr. Stava's views in respect of Diag Human. And indeed, there was no meaningful possibility of the trustee forming and seeking to act on a different view. And that was, we're not going to go there at the moment, but I'll give you the key references. That was at paragraphs 47 to 48 of Annex 3. Another key building block was the judge noting the absence of any realistic scope for conflict between Mr. Stava's personal interests and those of Diag Human and the Karuna Trust in seeking to enforce Diag Human's rights. And that, combined with the dependence of Diag Human on Mr. Stava, meant Mr. Stava was the determinant voice. And that was at paragraph 52 of the annex. Then also another building block, that the trustee had effectively delegated conduct of Diag Human's business and any associated rights to Mr. Stava. That was 53 of the annex. 54 was that Mr. Stava was uniquely placed to assess the value in Diag Human and best placed to realise it. At 55, that he was uniquely placed to administer the Karuna Trust, given its very limited and particular asset base. So those were the particular facts of this case, and there are a number of others, but I've just mentioned those key ones at the moment. They, of course, will not be present in every case, but they were in this case. What does that mean? The Czech Republic complains about the conclusion of the judge in paragraph 218. We don't need to go there, but it's the reference to their skeleton is paragraph 70, and that's core bundle 18, tab 25. But what the Czech Republic doesn't do is explain why the judge's conclusion at 218 is wrong, or engage with any of the principles of Liechtenstein law and the way that the facts of this case map onto them. And of course, it's not open to the Czech Republic to challenge the building blocks that I've identified in the annex, which includes, of course, his findings on Liechtenstein law and the application of that law to the facts of this case. So all you have is the assertion that there was in fact some inconsistency with Liechtenstein law, and thus that somehow the conclusion the judge reached results in some error in Liechtenstein law. But it's not specified what the error is in Liechtenstein law. It's not said what principle of Liechtenstein law is offended, or what the unacceptable effect in Liechtenstein law is or would be of the judge's findings. And instead, perhaps there's some hint that this might be wrong as a matter of English law, or there's some attempt to apply principles from English law. But as I will show you, English law and Liechtenstein law are, as the court will be well aware, different beasts in material respects.
In fairness to Mr. Dunning, his argument seemed to me to be that under Liechtenstein law, a beneficiary under a discretionary trust has absolutely no status of any kind. Doesn't even have a right to call for the winding up of the trust in certain circumstances, and therefore wearing his hat as a beneficiary or potential beneficiary or set law doesn't get Mr. Starver anywhere. And the fact that he's holding the bearer shares, he's doing so not in his own right, but as an agent for the trustee who is actually responsible in law for administering the trust and doing various things. And insofar as any functions have been delegated to Mr. Starver, those functions have been delegated to him qua agent for and on behalf of the trustee and not as a principal. I think that's, I hope Mr. Dunning will
That's how we understand.
that's how I think he puts the case.
With
So-
the added flourish that actually the trustee in law controls the shares held by Mr. Starver.
Indeed. So, but there's and I fully agree with your ladyship. That's how it's put. With this added gloss of inconsistency, if and this
Yes.
tension between a finding that Mr. Starver has de facto control and that there's somehow tension between that and Liechtenstein law. Now, of course, as I will develop in my submissions, there's a lot more to add
Yes.
to how my learned friend presented it. There was a particular focus on his part on Mr. Starver's status as a beneficiary. And of course, one of the material differences between Liechtenstein law and English law is there's no concept of equitable ownership or an equitable interest. And so it's a very good illustration in the sense of my point that they are different beasts. But that doesn't help him because, as I say, when one looks at the findings on Liechtenstein law in the annex, and in particular, the consistency between those findings and the facts and the judge's conclusion at 218 of a lack of inconsistency, he cannot get home. The other point will be, I'll illustrate this in very brief terms shortly, is that his presentation did not do justice to all of the other rights that Mr. Starver held. Some, absolutely right, on behalf of others, but a number, and in particularly significant respects, on his own behalf, in his own right. And that's significant for the assessment of the position as a
I
matter
think
of
the
Liechtenstein
point
law.
that you've just addressed really goes to the question of whether the more sort of general argument that if the trustee were acting in accordance with Mr. Starver's direction or instructions, he'd be in breach of trust. I think that's probably your answer to that point, isn't it?
The more general point,
Yes.
and part of what the judge was addressing in
Yes.
218, this
Yes.
idea of a standing mandate, and
Yes.
which simply didn't arise on the facts.
Yeah.
Indeed, I mean that if there, in fact, that it was common ground between the experts that were there a standing mandate and the trustee simply agreed to follow without thought Mr. Starver's instructions, then that wouldn't be permissible under Liechtenstein law, and that was common ground, and that was not the case, as the judge found. That was not the case that we, or that we were not advancing a case that there was such a position. But where we get to is in our submission, we say the judge was correct that de facto control by Mr. Starver did not infringe Liechtenstein law, the trust deed, or the validity of the trust. And there is no basis, we say, given the findings in Annex 3, that the conclusions that the judge reaches in paragraph 218 can be challenged. And we would say that's the most appropriate way to approach this. That there is no basis, we contend, to conclude as a matter of Liechtenstein law that the judge got his conclusions in 218 wrong.
This is quite, if I may say so, quite an extensive summary
Yeah.
of your submissions. I think we only want to hear them once.
I appreciate that, my lord, and I will therefore make a brief second point. In fact, I'll just finish on that first point, which is simply to say that UCOS, therefore, which my learned friend does place reliance on, we contend does not assist here, because on the facts of the case, my learned friend Dr. Parlett will address you on this, but on the facts of the case, that doesn't reflect our position, in particular as to the rights of the protector and the consistency of those rights with Liechtenstein law. The second point, my lord, that I just wanted to touch on has largely actually been addressed in the discussion I've had with my lady, Lady Justice Andrews, which is this point about agency. As I say, it's not correct to say that de facto control was that Mr. Starver held was all exercised on behalf of the trustee. That's simply not correct on the facts. Critical rights were held in his own capacity for himself. And even where he was holding rights on behalf of another person, the trustee or Diag Human, this was not, as the facts demonstrate, what one might call usual agency relationship. I've already taken or referred your lordships and your ladyship to some of the paragraphs of the annex where it demonstrates the unique connection that Mr. Starver had with this asset, in particular in establishing the business, running the litigation, and so on, and the deference, therefore, that the trustee showed to him. Again, features specific to the facts of this case. And none of those features, and therefore none of the conclusions we say that the judge reached, were inconsistent with Liechtenstein law. They simply reflected the factual reality. So, my lord, that does conclude my introductory comments. I appreciate I perhaps went on a little longer than anticipated. Dr. Parlett will now address the court on the first limb, the treaty interpretation limb, and then I will pick up later on the de facto assessment limb.
Very good, thank you.
Very grateful.
My lords, my lady, I will be addressing you on the first ground of appeal, what we've called the treaty interpretation limb. You've seen Article 11C many times. I'm not going to put it up again. But as you will be aware, the key issue that divides the parties is this. The defendants agree with Mr. Justice Foxton that directly or indirectly controlled in Article 11C may be satisfied by de facto control. And the Czech Republic says that de jure, or legal control, is required. Just to provide you with a roadmap of my submissions, first I'm going to address you on the applicable principles of interpretation, and then I'll be looking at the ordinary meaning of the terms of Article 11C in their context and in light of the object and purpose of the treaty. And in that respect, I'll take you through the terms of 11C, I'll look at the context, look at the object and purpose, I'll take you to some authorities, including prior investment awards and commentaries, and then I'll address you on the Czech Republic's misplaced reliance on a good faith interpretation. So turning to the applicable principles, the parties agree that the primary rule of interpretation is set out in Article 31 of the Vienna Convention. But there are a few points that divide the parties on the approach that you should take to interpreting this provision. My learned friend Mr. Dunning suggested to you that Article 31 prescribes a holistic approach. I think he said that a couple of times, although he did say it was his own language. We do not agree with that language. It doesn't find any basis in the rules itself. And in practice, it is actually sometimes used to elide the distinction between the primary rule in Article 31 and supplementary means of interpretation in Article 32. So we would caution against you adopting that language. But obviously what Article 31 requires is that you look at the ordinary meaning in the context and in light of the treaty's object and purpose. So there's not a substantive point of difference, but I would urge you not to adopt the language of holistic approach because of the way that that is used in the public international law context, which is different to the way that my learned friend Mr. Dunning is using it here. Now, ordinary meaning in Article 31(1), it is to be contrasted with special meaning, which is permitted under Article 31(4) of the Vienna Convention. Usually, a special meaning will mean that there is a definition provided in the treaty itself, and it will always require proof that a special meaning was intended by the parties. I won't take you to it, but that is discussed in Gardner at LA 107, page 8, if you want to see more on that. Context that can include other provisions of the treaty, including the preamble, and which commonly also expresses the object and purpose of the treaty. My learned friend Mr. Dunning also referred to general principles of law of civilized nations under Article 38(1)(c) of the Statute of the International Court of Justice. Now, Article 38 of that statute is not about treaty interpretation, but it is generally accepted to set out relevant sources of international law. These do include general principles of law, and in various cases, these have been understood to mean principles such as res judicata, estoppel, competence de la competence. These were examples that were given by Lord Lloyd Jones, and that's at LA 110, page 4. These might possibly be taken into account in treaty interpretation under the rule in Article 31(3)(c) of the Vienna Convention. It says that there shall be taken into account, together with the context, applicable rules of international law in the relations between the treaty parties. These are distinct from context, which generally means other provisions of the treaty itself. But I make that point because if one were to go down that path of saying that there is a general principle that is applicable in the relations between these two treaty parties, the Czech Republic and Switzerland, then the existence of the general principle as a general principle of civilized nations would need to be proved. The exercise would be similar to that approach where a party seeks to establish that there is a principle of customary international law. It would require analysis of multiple jurisdictions, including how the principle applies there, in what context, and what specific consequences it gives rise to. None of that analysis is before you, and none of it was before Mr. Justice Foxton either. And it's not sufficient to say English law, it's a principle of English law, and that's enough because this arbitration has an English seat. That was decided by the parties to this dispute, and it has no relevance to what the parties to this treaty agreed, and certainly doesn't make a principle of English law an applicable rule of international law in the relations between the Czech Republic and Switzerland. Now, assuming that it had been shown to you that there was some applicable general principle, then for it to come within Article 31(3)(c) of the Vienna Convention, and for it to apply to your interpretation, it would then have to be shown that it is applicable between the parties to the BIT, and no attempt has been made to demonstrate that either. It appears to us very difficult to say that a concept of domestic private law is a relevant rule applicable in the relations between the Czech Republic and Switzerland, particularly in the absence of any evidence that the concept applies at all, either in Czech law or in Swiss law. So even leaving, though, these deficiencies in the Czech Republic's argument to one side, the way it seeks to apply this general principle to the present case is very problematic. It says that this provides the basis for the Czech Republic's argument to the court that it shouldn't allow Mr. Stava to have it both ways, and to ignore the substantive legal effect of the discretionary trust under applicable domestic private law. This may be an attempt to use the general principles to take aim at Mr. Stava's subjective position, but it cannot form the basis of an objective interpretation of the treaty. So we would say if it is all relevant, it's relevant to when you come to apply your interpretation of the treaty, not to the question of what the objective interpretation is. But anyway, for the reasons that Mr. Richards has highlighted to you already in opening, and as Mr. Justice Foxton explained, the judge's conclusions do not require the valid and effective trust to be ignored in any sense. So it's really this point really takes the Czech Republic nowhere. In its skeleton argument, the Czech Republic also relied on Article 32 of the Vienna Convention on the Law of Treaties. That's the provision that allows supplementary means of interpretation to be taken into account. And it suggested that domestic trust laws were a relevant circumstance of conclusion of the treaty. Now, Article 32 was not mentioned at all by my learned friend, so we assume that this point has been abandoned. If it is not, we have addressed it already in our skeleton. That's core bundle, tab 20, page 19, at paragraph 44. So I don't propose to address you further on that unless you have any questions about it. But just before I leave the principles of interpretation, I just want to also highlight that my learned friend, Mr. Dunning, although he set out the principles by reference to the Vienna Convention, he then summarised the question before you in terms that just bear no resemblance to the Vienna Convention exercise. This is at day 2, page 154, line 2, if we can bring that up on the screen, the transcript of the day 2 hearing. Day 2, page 154. And starting at line 2, you see there the question starts, and so ultimately the question can be paraphrased as this. And I'll just leave you to read that, it is quite long. We say that if this question arises, it's a question of application of the interpretation that you reach under the Vienna Convention, not a question of interpretation. One doesn't interpret the treaty subjectively in a different way in any particular context. And as my lady, Lady Justice Andrews, noted earlier this week, interpretations have to be able to be tested by reference not only to the facts of this case, but they also have to be considered taking account of other circumstances in which de facto control might arise. The treaty and its terms are capable of and must be interpreted objectively. That was also mentioned to you by my friend Lord Verderame this morning in the context of the other appeal. I also note that there Mr. Dunning emphasised that the question had to be answered by reference to the point in time of October 1990 when the BIT was signed. This is not correct. It's widely accepted, including by the ICJ, that you interpret a treaty by reference to the meaning to be given to generic words at the time of its interpretation, not at the time of its conclusion. This isn't a point that we have briefed.
Does that mean the meaning changes over time?
It can indeed change over time, and this was confirmed by the ICJ in a context that I think shows precisely why. In the navigational rights case, which was a dispute between Costa Rica and Nicaragua decided by the ICJ in 2009, there was a treaty concluded in 1858 in the mid-19th century, and it gave Costa Ricans a right of navigation with purposes of commerce on a Nicaraguan river. The issue in that case was, what did commerce mean? And the court said specifically, you don't interpret commerce by what commerce meant in the mid-19th century. You interpret commerce by, it's a generic term, it has an evolutionary meaning, and you use the evolutionary meaning to interpret it at the time you are interpreting it, not by reference to the time it was concluded. So in that sense, commerce was taken to mean something broader than simply going on the river in order to transport your goods. It was interpreted to mean that you could do it for purposes of education, to travel places, to interact with other people, because that was held to be encompassed within the word commerce. So that demonstrates, I think, the very real impact that this can have. So far as this case is concerned, I'm not sure what significance Mr. Dunning places on the point of time of it being 1990. There is a reference in the Czech Republic's skeleton to the nascent law of trusts at that point in time, but I think that really goes to his overarching point about about those general principles being relevant, on which you've heard we have a number of points of why they are not. But I just wanted to mention this so that you have a complete picture. The relevant point in time is not October 1990. You interpret the treaty according to what these words mean today.
What you've told us about the case on commerce doesn't necessarily read across, because here we're dealing with an offer to arbitrate, consent in the sense of an offer to arbitrate. So that's certainly made to future investors when the treaty is signed. But you say it's made separately day by day and can change over the course of the treaty.
Well, the offer that was made in the 1858 treaty was an offer to navigate on the river with purposes of commerce. And the court held that that was to be interpreted according to what commerce meant on the day that navigation was taking place, yes. So that means that if there are different ways in which factual situations develop in which assets might be held, for example, that the fact that they were not in the contemplation of the Czech Republic and Switzerland in 1990 doesn't mean that they're excluded by the BIT. It may be that not very much turns on this point. Perhaps I can give you a copy of the 2009 judgment in case that would be helpful. And of course, if this becomes a contentious point, we can return to it. We don't see this as actually being relevant. We don't think the point in time is relevant at all. But we just wanted to make that point clear as a matter of principle, so that the court is aware of our position, that it is actually not that you approach this stepping back in time to 1990. So turning then from principles to the ordinary meaning of the terms. And as we know, and as I've already mentioned, we take this process all together. So it is ordinary meaning of the terms in their context and in light of the object and purpose of the treaty, as Article 31 of the Vienna Convention says. I will start, however, with the terms, and this is the treaty itself, supplementary bundle, tab 22, page 2, Article 1(1)(c). That's in your, I think it's in volume 1 of your hard copy bundles. So we see Article 1(1)(c), and I have 5 points about the terms of this provision. First, the key for our purposes is the ordinary meaning of controlled. I pause here because ordinary meaning does not mean the legal meaning or the legal definition under any particular domestic law. Control is not an inherently legal concept. It could be contrasted with something like citizenship or nationality, which must derive, at least to some extent, from domestic law. But there's no inherent legal meaning of control, nor is it an inherently legal concept. There is no overarching principle of control, even in English law, at least that I am aware of. There may be various indicia of control that apply in various contexts, statutory or otherwise, but there is no absolute legal definition. And the same can be said about other aspects of Article 1(1). Article 1(1)(b) refers to legal entities which have real economic activities in the territory of the home state. Real economic activities is not an inherently legal concept either. It requires factual analysis, and my learned friend accepted this yesterday. That was day 33, page 98 at lines 13 to 14.
It only feels like day 33.
I make no comment. That undermines the Czech Republic's argument that because the treaty is a legal document, the default approach is only to cover legal relationships. That's in their skeleton at paragraph 20. We don't need to go to it, but it's core bundle tab 18, page 18. The basis of this is not understood. It was set out by the Czech Republic in its skeleton, but it wasn't elaborated at all this week. Control is not an inherently legal concept, nor is it the case that all the terms in a legal document, whether it's a treaty or a statute or a contract, have to be legal terms. The Czech Republic's argument finds no support in the existing authorities, nor in any principle of interpretation. A treaty will always be a legal document because Article 2 of the Vienna Convention requires that a treaty is governed by international law. But that doesn't mean that the treaty only covers legal relationships. There is just no basis for that leap in argument. And no tribunal has ever reasoned that because the word control appears in a treaty, it covers only legal relationships. It's both simplistic and just unsupported. My second observation about the terms is that Article 11C does not explicitly or implicitly refer to domestic law definitions or meanings of control. Article 11C and B both refer to legal entities organised or established under the law of a contracting party. But when it comes to control, there's no reference to control established under the law of a particular state. It doesn't refer to control established under the law of the seat or registration. It refers only to control. So in that context, interpreting the term controlled does not refer to or entail a definition which comes from any particular legal system. And as we will see, this is how tribunals have approached it. They have determined the meaning of control from ordinary concepts of control as might apply in the particular situation. Had the two states wished to define control by reference to a particular domestic law or to the applicable domestic law, they could have done so, but they did not. My third observation about the terms is that the word controlled is not qualified in any way. My fourth observation is that it covers entities which are directly or indirectly controlled, and that language does carry a particular significance. As your lordships may be aware, the coverage of indirect investments has been the subject of some debate in the investment treaty world. And when it comes to protection of investments held, that's not controlled, but usually owned, some treaties exclude indirect investments, and some treaties are silent as to whether indirect investments are covered. But here we have the widest possible wording for control, expressly covering both the directly and indirectly controlled. And this suggests that a restrictive or a narrow coverage was not intended by these treaty parties. This also means that there is this possibility of having multiple qualifying controllers in respect of a single entity, which was the subject of some discussion between my Lord Justice Popplewell and my learned friend yesterday. If you have an English company, 100% owned by a Swiss company that has real economic activities in Switzerland, which has a majority of Swiss shareholders as Swiss nationals as shareholders, then the English company qualifies under Article 11C on the basis of either the Swiss company or the Swiss shareholders.
And that arises through an indefinite chain. Does it say that if there are 10 vertical companies before you get to that holding the investment and a different nationality of shareholder in each of companies 2 to 10 qualifies as an indirect shareholder, an indirect controller?
Well, on my learned friends test, if you are taking the shareholders, on my case, well, indirectly is not qualified in this treaty. So I would say it covers through any number of levels of chains, and certainly in some cases we don't have an indirect chain of anything, but in some cases you do have quite a number of layers. And I don't know whether it has extended to 10, but it's certainly extended to 3 or 4. And those cases it's found to be that the investment is indirectly controlled or owned. Yes.
At each layer?
Well, I don't know of a case where there have been claims at the same time by somebody in the chain and then somebody further up the chain in respect of control. But if they were to seek to bring a claim, there would be potentially issues about double recovery if you sought one proceeding under one treaty for someone in the chain and a proceeding under another treaty in respect of somebody higher up the chain.
Not quite.
But in principle,
we're concerned with whether the person's an investor.
Certainly. My only point with respect to the directly or indirectly language is that because there are treaties that are not so broad, this indicates that these treaty parties did not objectively intend a restrictive coverage of the treaty.
I understand that common ground, you can have at least two people. You can have one direct and one indirect. What I'm just exploring is whether it's your case, you can potentially have much larger numbers.
There have been some cases, and we'll come on to discuss it, where control has been established by a number of shareholders acting together. And that might go in part to my lord's point. But it may be better to come on to those when we discuss the cases, because they're all quite fact specific, which we say is just a natural part of the exercise when you're looking at the question of control under one of these treaties. My fifth point on the terms of Article 11C is that it refers to entities which are controlled. Now, the Czech Republic put some emphasis on the word controlled as opposed to control before Mr. Justice Foxton, but ultimately he concluded that that did not assist on whether de facto or legal control is covered. And the protocol on which the Czech Republic places particular emphasis, it uses the term control, not the term controlled. And we didn't hear anything on this from my learned friend this week, so we assume that any point of distinction on that is not pursued. But I mention it because some of the treaties in the cases that the judge found to provide some guidance, some of them use the word examining treaties which use the word control, and some of them are treaties which use the word controlled, and we say they're equally helpful to you. I turn then to the context, which is a larger topic, but I may be able to finish one part, which is the preamble, before the lunch break, if that's convenient to my lords. We do rely on the preamble. This is at page 1 of this document. And it expresses the object and purpose of the treaty as encouraging, protecting, and promoting investments. So in the third paragraph, we see that the treaty is intending to create and maintain favourable conditions for investments by investors. And the fourth paragraph refers to the need to promote and protect foreign investments. And these paragraphs reflect the fact the purpose of the treaty and of investment treaties generally is to offer protections in the treaty to stimulate foreign investment. Now, there is a point taken against us on this. The Czech Republic argues that the object of stimulating and promoting or protecting foreign investment does not mean that an interpretation is always to be favoured for an expansive approach in investment arbitration. That was my learned friend yesterday at day 3, page 18. Now, we agree in principle that these statements in the preamble do not have the consequence that Article 11C should be interpreted as broadly as possible. The correct approach was recently discussed in Career and Elliott by Mr. Justice Foxton at paragraphs 22 to 23. That's LA 29.1, pages 7 to 8. It's in volume 7 of your hard copy bundles. If we could turn that up. Page 7. Paragraph 22. You can see that the suggestion's been made to him that jurisdictional provisions in investment treaties are to be interpreted neither liberally nor restrictively. And I take you to this because he is dealing with a submission that was made on the basis of the ICS award, which Mr. Dunning took you to yesterday. Perhaps you could have a read of paragraph 22 and then also 23 over the page. So you see there that Mr. Justice Foxton did not find the ICS award that Mr Dunning took you to be persuasive, and he declined to accept Korea's argument that a claimant must prove consent with sufficient certainty or jurisdiction will be declined. He preferred the more even-handed approach in Swiss borough as consistent with the Vienna Convention. And that is a point that we agree with. So going back to the preamble, the expression of the object and purpose there, they do counter against a restrictive interpretation. But what they don't do is to say that you should interpret everything as liberally as possible in favour of the investor.
I think one of the things that's really an issue is that they favour a restrictive interpretation of 11C, at least to this extent, that 11C can't have been intended to bring in as a qualifying investor an entity where there is no, in our case, Swiss economic interest, either at the immediate level or at the controlling level.
Well, I think that is made as part of a broader point about interpretation of the treaty generally, when you take Articles 1A, B, C together, rather than just based on the preamble. And then the Czech Republic has a different argument based on certainty and predictability, which also feeds into that.
I mean, more specifically, it is that if 11C means solely de facto control, and you can have de facto control without having any ownership interest, it would enable the treaty to extend to a German company owned by a French company to whom powers of attorney had been, who had delegated powers of attorney to a Swiss national who had no economic interest in it at all.
Well, I think
Yes. That would be contrary to the intended purpose in the preamble.
My recollection is that Mr Dunning was reluctant to accept that the power of attorney would have been sufficient, but I take the point that his argument is that part of the...
Yes, he says power of attorney would not be sufficient, and
No.
part of the reasoning which he supplied, or possibly I supplied, but part of the reasoning may be because that would enable the control criterion in 11C to be fulfilled and allow the company to recover the company's, my example,
Yes.
the German company's economic interests, where there were no Swiss economic interests at play at all.
Well, Article 11C does not condition control on an economic interest. And we'll come on to look at how this has been discussed in some of the cases. I know that Mr Dunning placed some emphasis on the ADT award and that you've looked carefully at that quite elliptical paragraph 242, which Mr Justice Foxton could not make sense of. That is one view which has not necessarily been picked up by other tribunals which have found de facto control to be relevant, to be sufficient, and have not relied on the presence of any economic interest in order to justify their findings that an investor comes within the protection of a provision such as Article 11C. So although the hook is in the preamble, I think again this is a point that we'll have to deal with in some detail by reference to some of the cases that I'm afraid my learned friends didn't show you, but I will. I'll also come back a bit later to the certainty and predictability object and purpose argument that the Czech Republic makes, which we say is really just another attempt to introduce a restrictive approach to interpretation under another guise. But that may be a convenient point because I'm coming on next to our favourite protocol after lunch.
You want to stop now, do you? Yes. All right, 2 o'clock.
Yeah,
Is that clock slow?
No, it's one. The
Okay.
clock is 5 minutes behind.
Did I wait? Did I lose too much time?
So if you know your lease can be terminated if you're not adopted.
Is there a cafe? Yeah.
Even on
I joined a few years ago, but I haven't been in since.
Well, I think it was probably quite a justifiable comment because I thought this was a brief introduction.
Yeah, that's true actually.
It's like, yeah, all right, you got that.
It's fine.
Yeah. Look, maybe TV at the moment. It's just so the money is so loud. Yes.
You're in the same boat.
Oh wow.
It's like a shift.
I mean, it's you've got to love it. Like
It's
the money is you can't it's a full season of drama show last year.
Some mistake.
They're bringing Bergerac back. I was in every episode. Quite a big role. Yeah, but it's not like, you know, I took 6 months off.
It's changed many ways rather than did
Fix at 1.9.
I think you're fine. We just want to be a quick
Yeah,
consumer,
fine. My wife said
shopping
fix for
around
10
the
years.
last-
Yeah, well, you want to say she needs to make sure those
I'm
are
going to fix at like 2
Yes,
Yeah.
the court,
Okay, and then I did 2 episodes of Silent.
she wants to review them and then come
So surprised I got paid less.
No, not then, but I think
It's mad. And but 5 years
Basically,
ago.
you need to be a film star.
Yeah, but 5 years ago, the money was double.
Oh, that's interesting. That's really interesting.
Like I probably could have put a deposit on a house with the show that I did last year. Now, I mean, I didn't have to work for 6 months, but it's not you have to love it. You have to absolutely love what you're doing.
Yeah, yeah,
Because you
yeah.
don't get the money is
What channel will Bergerac be on?
you on Now TV.
Okay,
Now TV, yeah, and then Sila's on Apple. But God, don't know what's going to happen next.
I'll run and I'll
Yeah. But I'll give you my email if your daughter ever has any questions or anything.
I mean, she's little at the moment.
yeah,
she's only
in the
10,
future.
but it's what she absolutely loves.
I wish
and
I
as say,
had
she's-
more knowledge about because drama school and schools they're run by teachers that have never worked in the industry.
Yeah, she's not going to a drama school.
but
She's
when
going-
maybe next,
yeah.
you know, maybe in
she's
down the
going
line.
to a school, but she's been given a drama
Yeah,
scholarship.
But
so-
down the line, if she ever has any
That's really
questions,
hard,
I'll definitely tell them.